Oh, Mr. Arguelles, are you on the docket?
For Mr. Acuna, I filed the notice of appearance on it, the case from yesterday.
Okay. Oh, what? That's what you're here for today?
Remember you reset it for today?
Yes. Where's Veronica Legareta?
Well, I filed a notice of appearance, so I'm now the counsel of record.
Oh, so you are not appointed, you're retained?
Correct.
Oh, okay. All right. Thank
But the
you.
state just brought the file because they didn't add it to the.
Okay. Look at you making things happen. Thank you so much. Oh, no, I didn't. I went before. We were talking about work and new things.
I thought you said you were gonna go out, like have fun. Even though it's
Oh.
a state of turmoil right now.
No, I haven't gone in about 2 years. It's about time.
I leave in 2 weeks, so I'm ready to go.
Oh, where are you going?
London, Croatia, and Greece.
Okay, I love Greece. Which parts of Greece are you going?
Athens and Mykonos. I've never been, so it's my first time going there.
Oh my gosh, Mykonos is so beautiful.
I've been only in Mac.
And you know what? I love going to a place where you go to a restaurant and you're ordering off the menu and they say, we'll have to see what came in on the boat. It's super fresh. But I absolutely loved Mykonos. And I just love the breezes and walking around.
Just looking forward to sitting down on the beach, not having to answer my phone for this.
Oh, and do not answer your phone. And then where she say Croatia? Please take some pictures of Croatia. I hear that it's so beautiful and I've never been.
We're not doing Dubrovnik, we're just doing Split. Like we're saying, it's just a vacation this time.
No, but that'll be beautiful.
Right?
Yeah, I still think it's gonna be great.
And then
Oh yeah, and I'm telling you, do not answer any phone calls.
I file vacation letters in every court. I'm done.
You're done, okay? Make sure, I'll remember, but make sure Norma knows that you're on vacation.
Nothing's like I'll make sure there's everything for 2 weeks.
Okay.
Yeah.
All right, everyone, today is Tuesday. I'm gonna call the docket. Please let me know if you are here. In custody, we have Gregory Witron. All right, thank you. We have Melvin Jones in custody. Jose Lozana. Thank you. In custody, we have Sergio Salinas, Gilbert Gonzalez, Pete Garcia. In custody, we have Raymond Ruiz, Courtney Pride. Thank you. James Brooks. Thank you. Good morning. David Leon. Thank you. Felix Apolinar. Thank you. Manuel Gaytan. Manuel Gaytan. Oh, custody. Okay, thank you. In custody, we have Eleazar. Is that pronounced Ibanez or Ibanez? Ibanez. I butchered that 3 or 2 different ways. Alvino Acuna.
We'll be here shortly.
All right, thank you. Todd Dotson, custody. Timothy Nichols. Patrick Vargas. All right. All right, is there anyone who's present and your name was not called? Oh, look at this. Oh, just have a seat. I know that you're here, Mr. Sanchez. Yes, what is your name? Courtney what? How do you spell your last name? All right, do you know who your attorney is? Do you know your SID number or case number? All right, we're going to get right with you. Yes? All right, do you know who your attorney is?
No, I was subpoenaed.
Oh, you were subpoenaed?
Yes.
All right, just, do you know which case you were subpoenaed for?
Yes. 2022 CR 4368.
All right, just have a seat. We'll get with you and we'll find out what that's about. Yes?
Yes.
Daniel Santos, do you know who your attorney is? All right, do you know your seat or case number? All right, just give us a moment. And then to the person standing. I'm sorry, what's the first name? Do you know who your attorney is? I'm going to take that as a no. All right, just give us a moment. We're going to get with you. All right, everyone, this is felony court. It's very serious. You should know who your attorney is, at least their name. All right, these are the rules of the court. On this side, there are files that are criminal trial division files. Attorneys just grab those files, place it on the prosecutor's desk, and they will take you in the order in which they receive your file. Over here is family violence. Just grab a file and place it there and then have a seat. Do not approach the court if you have not conferred with the state and conferred with your client. If your client is in custody, then your client will need to be brought out. If your client speaks or is more comfortable speaking in a language other than English, there will need to be an interpreter, whether you speak that language or not. Once you request your client from the back through the deputy, please do not leave, because for security reasons, the deputies can only bring out so many inmates. Once you requested an interpreter, please do not leave, because there's a shortage of interpreters. So today is Tuesday. The good thing about Tuesday is we are closer to Friday than we were yesterday. So that's something to be happy about. So everyone put some patience in your pocket, kindness in your heart, and use it as needed. All right, everyone, please confer. And if I could see the parties on JUAN GARCIA-SANCHEZ. And if I could have the interpreter. And Dinah, we're on the record. And Mr. Sanchez Garcia, if you come forward.
You want to interview?
No.
Okay.
No,
All right, we're on the record in 2019 CR 6322, State of Texas versus Juan Antonio Garcia-Sanchez. Could I have parties announced for the record for the state?
Travis Banks and Ruben Herrera for the state.
Defense?
Rafael Allen, Brian Kimbrough for the defense.
All right, and are you Juan Antonio Garcia-Sanchez?
Yes.
All right, the interpreter who is here has previously been sworn in, and you're still under oath. All right, yesterday we received a question from the jurors. The question was, the jury cannot make a unanimous decision on all 5 counts. What is the next step? Without objection from either party, the court allowed the jury to recess until today at 9 a.m. The court gave each party 3 suggested answers to these questions. Have both parties had a chance to review each suggested answer? State?
Yes, Your Honor.
Defense?
Yes, Your Honor.
All right, is there an agreement on which answer either party would like sent back?
I don't believe we've conferred on to see if there's an agreement.
All right.
I think the state like 3 best, if we're just throwing it out there.
All right. Which one are you all requesting? Defense?
Your Honor, we are objecting to all of them. We are objecting to the fact that this would be the second Allen charge given to the jury. They have been deliberating for, I'm not exact on the time, but approximately 7 hours, 8 hours yesterday. They have not indicated that they were deadlocked. I think.
Counsel, they say that the jury cannot make a unanimous decision. What do you mean they have not said that they're deadlocked? They're saying in the question, the jury cannot make a unanimous decision on all 5 counts. What is the next step? Now, the way the court reads that is they want to know what the next step is. Am I wrong in my interpretation of what they're requesting?
Well, Your Honor, I believe that the charge that was given, and I don't know whether we recorded the times when the Allen charge was given, and on when they sent the first impasse, because there was a first impasse that they mentioned to the court, and then the court sent the Allen charge. And then the second notice came, the one that you were just reading. What I'm saying is that it brings to the fore the weakest link in the jury room. It brings to the fore the notion that the person or persons that are not agreeing with the majority are therefore wrong in their position.
Just a moment. What are the questions from the jurors, previous questions? All right, thank you. All right, you may continue.
And what it does, Judge, giving them an additional Allen charge, which they already have, and it was a proper Allen charge, it's coercive. I have never had a case where there was repeated Allen charges given. The coerciveness, the Allen charge by its language is coercive enough. Now we agreed to it and it was given. And then the jurors deliberated after the Allen charge, and then they came back with an additional question of an impasse. There was nothing after the Allen charge that was given that were given to the jurors to move them from their position or to change anything concerning that. There was nothing else, no communication given to them. By the time they sent their last impasse that they were not able to reach in a unanimous verdict on all counts. What I'm saying is that it pressures the jurors by improperly casting a light upon them of a personal responsibility and sense of guilt at the impasse. That's what I'm saying.
Do you not want the question answered?
What I'm saying is that perhaps what we can say is that refer to the last response of the court and let it go at that and continue deliberating, because they cannot say, they haven't used words to the effect that they are locked down, that it's impossible, that, or anything like that. What I'm saying is that at most, the court can say, please refer to the last response from the court to your last question and continue deliberating.
So then what you're saying is the question that was asked, what happens if we do not agree on all 5 counts? Then you're saying you want the previous answer that the court gave, which was your presiding juror has advised the court that you have not been able to reach a unanimous decision on all of the alleged counts. In connection with such communication, I advise the jury as follows. The jury verdict on each count must be unanimous. Is that what you want them to refer to?
I'd rather just refer to just send a note back, continue deliberating.
No, I mean that the question must be answered.
The response will be continue deliberating.
No, the question is, the jury cannot make a unanimous decision on all 5 counts. What is the next step?
Could I add something?
Sure.
Rather than put in an additional charge, I mean, to me, there are 2 possibilities. One would be to resubmit the original charge that you gave yesterday, or another would be a note that said, refer to the charge that was given yesterday. Because the charge that was given yesterday answers the question. But even in our position, is it even re-urging that charge in writing is, saying the same charge over, has a coercive aspect. You've already given the charge. I think the correct decision would be to send a note back saying, refer back to the last charge, because the last charge answers the question. Now, at most, you could put the original charge that you put in last time, put it in again, but I think that does have a coercive aspect. An additional Allen charge would be unprecedented, I think, and it would not be
I don't think it's unprecedented.
well, my experience.
Well, I mean, courts and there's case law that I found of the Fifth Circuit, where it says that the Allen charge, by its very nature, it's coercive. It tests the limits of coerciveness.
Well, is it coercive or does it test the limits of
It goes-
coercion?
Up to the border of.
But it doesn't cross
It
it.
doesn't cross it.
Okay.
Granted, okay?
Your Honor, and let me just say, if defense had an objection to the Allen charge we sent the jury yesterday, they should have made their objection yesterday.
No.
This objection is
And I'm
untimely.
All right,
objecting-
wait, stop. Everyone. See, this is what happened when people stand. People tend to overtalk each other. So I've reminded you all this during jury trial, and I'm gonna remind you again. Number one, and maybe this is a question for you all. What do you all have against the interpreter? She's a nice lady. You all are talking over each other, and you're asking her to interpret what two people are saying at the same time. It cannot be done. Then what do y'all have against the court reporter? She's a nice lady. When you talk over each other, she can only take down, I know she can, she's a professional. I know she can take down two people at one time, but let's not do that. If you all are trying to make a record, you all should not be talking over each other. Now, I will hear each of your arguments. You all don't have to interject over each other, because guess what I'm gonna do? I'm gonna hear your argument. The state has already told me which supplemental charge they would like. I've heard that. I'm gonna hear your argument, and after you finish your argument, I'm sure the state is gonna have an argument for you. And guess what? I'm gonna listen to it. So I want everybody to be patient in making their arguments and hearing arguments. And if everybody can actively listen to each other, okay? So, Mr. Leal, where we left off, it came up to the line of coercion, the case law that you cited, but it didn't cross it. It may have knocked on the door or walked up to the house, but it didn't walk in. Or who knows, maybe it didn't even go into the curtilage. We don't know.
That was my preamble to the court saying, they said an original Allen charge goes to the limit of what is, before we can call it coercive.
Mhm.
A second Allen charge, the court says, is unduly coercive. Okay, it should not be given.
But you and defense counsel are telling the court that the answer you would like the court to send back is refer to.
Right,
The last Allen charge.
which already went in and we
Already
didn't
put in,
object
they
to,
have it.
and we didn't object to.
One at a time.
And they already have it, they can refer to it, they can continue deliberating and reach whatever decision they deem appropriate and necessary. Because see, if we continue giving them Allen charges, then it pressures the jury.
All right, so here's my
Legitimately.
question. Let's get to the point. Here's my question. When you say refer to the last answer or the last supplemental charge that was given to the court, how do you want the court to state that? If the court were to do that, or you wanted to say, refer to the last answer given to your question of what happens if we do not all agree on 5 counts? Is that what the defense is asking?
I'm not asking to highlight the question that they pose, because then you already know what the question.
Well, how do I get them to refer to something
Okay,
without telling them what they're supposed to be referring to?
the Allen charge previously given.
They don't know what an Allen charge is because this doesn't say Allen charge.
Previously given to them.
But-
The last supplemental charge.
But the way these are labeled, I am unsure if this was the last question. I think this question came somewhere in between the other questions, which means I can't say refer to the last instruction we were given because this was not the last question that we received. We've received 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 questions from the jury.
Judge,
So,
were they stamped when they?
yes, and I will tell you, the last question was not what happens if we do not agree on all 5 counts. That wasn't the last question that we received from them. So
What was the time of that one?
I'm telling you, it's not the last one. That's what I'm telling you.
What I'm saying is that,
Mr. Kimbrough.
can we refer to the,
Well, Your Honor, I object to multiple counsels arguing in the same hearing. Local rules require one counsel per.
Oh, I'm fine with hearing from everybody.
I don't want to interrupt anyone. Just an idea. I mean, I believe there's only been one supplemental charge, correct?
No, when you do these and you answer, all of them are called supplemental charges.
are they labeled or if they are?
They're labeled as supplemental charges. None of them will say, this is the Allen charge.
Well, then,
So,
So the only thing that can be done, if I'm going to give you what you're asking for, I'm going to have to ask them, review the supplemental charge that was given to you from the question of what happens if we do not agree on all 5 counts.
that's fine.
that would be fine with us.
I think we should just send them the charge. Your Honor. They already have it. Defense didn't object to it. Now they're saying they do object to it. We should just send them the charge. They can read the same charge that they are.
So we're objecting to a second one, whatever if it's
Here's
even
my-
if it's the same.
My question for the defense. If the supplemental charge states, in regards to your inquiry, please refer to the supplemental charge that was given to you with the question, what happens if we do not agree to all 5 counts? And here's the other thing to consider. Once we answer these questions for them, they give them back to me. So what I would have to do, and when I say me, I mean the deputy, all of these answers to their questions, all of these will have to go back to them because otherwise they don't have anything to refer to. So have you all thought about that?
They don't have a copies or
No.
anything?
There are no copies. It's this. So I would have to send back all of these to them. So is that what the defense is asking?
The responses to each and every question? that they have?
Every question will have to be sent back to them because you're saying that it's crossing into the territory of coercion and you just want the court to say, refer to the answer to the question, what happens if we do not agree on all counts? Is that what you're asking for?
My first position will be to continue deliberating.
That's not answering this question.
I think in a way it's answering the question.
No,
Okay, we, what's the next step? Continue deliberating, continue talking about it.
counsel, you keep agreeing to things. And then when I give you what you want, then you say you want something else. You're the person who, if I say, what do you want for dinner? I want steak and lobster. Are you sure you just don't want all vegetables? I want steak and lobster. And I say, okay, I'll give you steak and lobster. Well, I know you're giving me the steak and lobster, but now I want the vegetables. I don't want the steak and lobster. So what do you want?
Send back everything, Judge.
All right. So you want everything sent back and you want the supplemental charge for this question to read. Please refer to your previous question of what happens if we do not agree on all 5 counts. Is that what the defense is asking for?
I'll review everything that we could.
No,
Yeah.
counsel, you just said you want them to refer to this. And this that I'm holding was the previous question of what happens if we do not agree on all 5 counts. And you said the answer you want sent back is please refer to the answer of the question, what happens if we do not agree on all 5 counts?
That would be my second choice, George.
No, you said it was your first choice.
No,
Mr. Kimbrough, did he not just say this was his first choice? That's what he wanted. And I don't want to bring
You
conflict.
can't ask me to be a witness again.
I don't want to bring conflict. I'm a witness to it.
Here's our position, Your Honor. Our position is that ultimately, if the court feels that it needs to respond to the question, other than saying continue deliberating, that sending back, as we said, a note that would say, refer to the earlier supplemental charge given, and in response to that particular question would be the next choice. That would be okay, because
All
we
right.
didn't object to that at the time, and we don't, and so we're not
And you're not objecting to it now.
objecting to it now.
All right, so
So
here's the
you-
thing. Thank you very much. State, I understand your position. And you're saying that you want number 3, is that correct?
Yes, Your Honor.
All right, could I see what number 3 is, please? Thank you.
Yes. And just for the record, Your Honor, although the state did say 3 was preferred of all of them, the state also has no objection to just sending back the original charge. That's just as fine of a solution for the state.
All right, we're off the record for a moment. Can you mute us, please? All right, we are back on the record. All right, to the question, the jury cannot make a unanimous decision on all 5 counts. What is the next step? The court proposes the following. With reference to your inquiry, please refer to the supplemental charge given to you in response to your question asking what happens if we do not agree on all 5 counts. Please continue your deliberations. Any objection, state?
No objections from the state, Your Honor.
Defense, any objection?
No objection.
All right, thank you.
Thank you.
Thank you, Your Honor.
Yes. State and counsel, I'm so sorry. Defense. Mr. Leal. Right. And we're on the record. So with regards to the question and answer that the court has sent back, you all only wanted the one question sent back. Is that correct?
Yes.
With the previous question that was answered. Is that correct? All right. So that's what the court has done.
All right, thank you, Your Honor.
All right. Thank you. Yeah, I know. They're trying to make it into a Monday. Talking over each other. Timothy Nichols.
I'm here for him, Judge.
All right, thank you. All right, where's Mr. Nichols?
He should be on Zoom.
No, he's not.
Well, he texted me that he was, Judge. I'm in contact with him right now.
No, I'm telling you, there's no one in the room.
I believe you. I'm going to remove myself from this courtroom. I've done all I can for Mr. Nichols, I feel. And that is my announcement to the court.
All right, so we will call it. The court is calling 2023 CR 2219, State of Texas versus Timothy James Nichols. Could I have parties announced for the record for the state?
Lindsay Shaw from the state.
Defense?
James Tochi, Judge.
Uh,
Okay, so real quick, I'm so sorry. I literally got a text that he needs the password, but the password is contained in the email that I
there
sent.
is no password.
There is no password?
No.
There's not? I didn't, okay.
All right, thank you, state. He's going to continue to try to get us.
Email me and said, what time you have?
I told him 9 and I told him I'm here now and
And so when was the text sent to him?
I sent him the link this morning, Judge, around 8:30.
Oh, no, I'm so sorry. There's a do. Yes, I changed it. So it's not his fault. Can you give him this password, Ms. Ferguson?
Oh, there is a.
Yes. All right. So look at this.
Sometimes.
See, Mr. Toshi, you're saving lives.
Excuse me, I'm on personal space, sir. Okay, do you want me to remain, Judge, or
Yes, because he should come in right away.
if he does, will you call me back to the bench, please? Please.
How far away are you going to be? I mean, it should take him 2 minutes to, have you conferred with the state?
I have. Ms. Shaw and I have been in the conference with each other.
And have you conferred with your client?
Yes, him and I have talked as well. He's kind of at distance, Judge, so it's our first setting post indictment and it's kind of, I need to have some more heartfelt discussion with him. I do anticipate resolution, but it won't happen obviously today.
All right. So has he informed you if he's received your text and that he's zooming in?
No, ma'am.
All right. Ms. Ferguson? Can you, here's your client now. See, and you wanted to leave.
Well, I still do.
Mr. Nichols,
Yes, ma'am.
you need to show, you are in a basement.
No, ma'am, I'm in the living room.
All right. So, Mr. Nichols, where are you? Which county?
I'm in Waco, Texas.
Okay. All right. Defense, have you conferred with the state?
Yes, ma'am, I have, Judge.
State, were you able to tender an offer?
We did not, Judge, at this time. No, we did not.
Yeah, she's gonna review it a little bit more closely and then get me the offer. And between that time and our next setting, I'm gonna convey it to Mr. Nichols, and him and I need to have some heartfelt discussion as well.
All right. So offer is going to be tendered off docket. And state, when will you be prepared to make an offer on this?
Judge, I can review the case this afternoon and
Okay.
email defense counsel in the next couple of days. Or 2 weeks.
All right. And defense, do you,
Time between now and 2 weeks from now.
she's gonna email you to this afternoon, so we'll come back tomorrow.
Let's get, exactly. Let's give Ms. Shaw 2 weeks.
Yeah.
Yeah, I might need more than a
Yeah.
day.
So do you have all the discovery?
I believe I do, Judge. Yes, ma'am.
All right, Ms. Ferguson, can you set this for the second week in June for a plea deadline date, the week of June 12th? All right, is June 15th good for you?
Yes, ma'am.
All right, Mr. Nichols, your
Yes,
plea
ma'am.
deadline date is going to be June 15th. Do you understand?
Yes, ma'am.
All right, and I will allow you to appear by Zoom since you're in Waco. But if
Yes,
on
ma'am.
June 15th, you're in Bear County, you'll need to be in person. Do you understand?
Yes, ma'am.
All right, is there anything else from either side?
No, Judge.
No, ma'am.
All right, you're excused.
Thank you.
You're welcome. Thank you again. Norma, make sure that it's in there that he can appear by Zoom. Melvin Jones. Melvin Jones, Mr. Porter.
I'm sorry, Judge.
Oh, that's okay. Are you ready to proceed?
Yeah.
All right, state.
Yes, Judge.
In the middle.
Hello, Mr. Jones.
Oh, I'm sorry. You're on the right. I'm sorry, Your Honor. I'm over here fighting with the state.
Oh, no problem.
Both ganging up on me.
Well, at least there's no bloodshed, so that's good. All right, so state, with regards to this case, if we were going to trial, which case would you all be proceeding on?
It'd be the drug case, Judge. It's the 2022 case.
85.9.
Okay, so let me just. All right, so the court is in receipt of the discovery. Counsel, have you received all the discovery?
I have, Your Honor.
All right, so we're going to go on the record. The court is calling 2022 CR 8529, State of Texas versus Melvin Jones. Can I have parties announced for the record for the state
Daniel Escobar for the state of Texas.
defense?
Robert Porter for Mr. Jones.
And are you Mr. Jones?
Yes, Your Honor.
All right, so the court is in receipt of the acknowledgement of discovery. Defense, have you received all the discovery?
I have.
All right, and were you able to review that discovery with your client?
Yes, sir.
All right, the court will find that the state is in compliance with discovery. The court is in receipt of a motion in limine. Is this the only motion the court needs to be heard?
That is correct.
All right, state, have you reviewed the defense's motion in limine?
Very briefly, Judge, Mr. Porter showed me before we came up.
Okay,
And with the exception of number 6, Judge, we're going to rely on 1, 2, 3, 4, 5, and 7.
all right, 1, 2, 3. Which ones? I'm sorry, counsel.
4, 5. We're just scratching number 6.
Okay, so you're sketching number 6. Okay. All right, so with regards to your motion in limine, counsel, I don't know anything about the facts of the case, so I don't know if it's relevant or if someone opens the door to anything. I assume Mr. Porter's not going to open the door to anything that he doesn't want the door open to. So with regards to number 4, that should be granted unless it somehow becomes relevant or, all right. So with regards to the defense's motion in limine for all of these numbers, state, before you plan to question anyone about this, you'll need to approach. And we can have a hearing outside the presence of the jury. So Mr. Jones, what that means is that the state is not going to mention anything that's in this motion without approaching the court first, and it'll be done outside the presence of the jury. so that there can be an argument by both parties and I'll make a decision on it. You understand?
Yes, yes.
Okay.
Sorry.
All right. I mean, there are some that I don't see how it will become relevant, but I just don't know until I start hearing the facts of the case. Is there anything else?
No,
All right. So how long do y'all expect this trial to last?
Probably 2 to 3 days.
I anticipate a not guilty on herself a few days.
Okay. I like the confidence. All right. Let me ask you all this. How long are you asking for jury selection?
45 minutes.
Yeah, that sounds about right, Judge.
45 minutes? Okay. All right, so what we'll do is we'll have the jury come up here at 11. I anticipate on releasing them for lunch if we're still actively in other cases, and then we'll come back and do jury selection in the afternoon. So if everyone can come back here at 11 to see where we are, and then we'll go from there.
Thank you.
All right, thank you. Do you have any questions, Mr. Jones?
Yes, would I be able to talk to my attorney?
Yes.
Oh, yes. You all can stay and talk as long as you want to in the box.
Yes, thank you.
You're welcome. Nona, can you call the jury for 11? Oh, no, 1:30 is fine then. We can keep it at 1. No, that's fine. See, that's me anticipating what you've done. Okay, thank you. I desperately need to take my allergy medicine.
We have somebody that-
Garcia.
Yeah, approach judge. I'm gonna hand you a copy of this MTR and you're gonna immediately recognize the name. Now, my duty is on for a class A misdemeanor.
Okay,
So I was gonna see if you would set a bond so I can get that and get it set up for a hearing.
all right. Have you conferred with the state?
Now I would figure they would be in opposition since he likes to smoke so much weed, but frankly, if anybody should smoke weed, it would be this guy.
All right, so if you will talk to the state and confer with them,
Sure.
and yes, it's on this side. Oh, it's theirs.
And then, is it okay if I talk to him Monday?
If you have them pull the file.
Can I tell you a story? I was at White House. I lost, I got a injury on rights. It's 9-3. So I had to go talk to the He said, she elected it is that you're gonna win the trial. I said, well, it was 9-3, not 50. So it was 25% chance I should have. I said less than that. Just, yeah. And that's what. Yeah, it was on.
We talked about the words.
Everyone did left for.
But it was turned on.
Yeah, it's a girl.
Yeah.
She's the one that told you what the way you want it. Well, here's a-
So you're doing wrong. So yeah. So I'm trying to do that, and you count whatever, yeah, I was making sure. We did to do punishment, we assess. Is it probably for the case? I'll say jail, so that it has to. And it's say jail, yes. Okay, go back to. So the minimum would be to use
Deputy Laura. Deputy Laura. All right, Alvino Acuna. Where's Mr. Acuna?
He's coming up on.
Oh, I know, he's on crutches. Norma, can you make sure that in the system, it shows that Mr. Acuna is now represented by Mr. Guayas? Just one moment. All right, thank you. All right, Mr. Guayas, where are we?
I conferred with Mr. Banks on this matter, Judge. They conveyed to us an offer. We are respectfully declining the offer at the moment. We are.
All right, do you have all the discovery?
We do, yes, Judge. And we're asking this court for a trial setting as soon as possible.
All right, Ms. Ferguson. I need a 2-week reset on this case for plea deadline date. Mr. Acuna, this is what the plea deadline date means. If you choose not to accept the plea, the court will not consider any plea bargain agreements with that good cause. Otherwise, you have to plea open to the court after the date I'm going to give you. Do you understand?
Yeah.
All right. Since you just received the offer today, I want you to have a chance to think about it. What date, Ms. Ferguson? All right, so we'll be back.
Defense counsels, that's when I leave. I leave on vacation, application letter and file
Ah.
31st to the 14th.
Oh, Norma, should we let him go to Greece? He's going to Greece, Croatia, just traveling the world up. All right, what's,
When do you have surgery?
all right. Mr. Arguelles, is the May 30th okay with you, or is that when you're gone?
Correct, Judge, that's when I'm gone.
Okay, when do you leave?
I leave the 30th and the 8th, like.
All right.
3 o'clock.
So, Mr. Acuna, if I give you till May 25th, that's enough time for you?
Yes, ma'am.
All right. Ms. Ferguson, can you put it on May 25th?
Yes.
All right, so May 25th would be your plea deadline date.
Medication, the bipolar. Okay.
All right, Mr. Guez, I hope you have a fabulous time. I know you will.
Oh, yeah, I'll see you back. before then.
Okay, unless you find this great job over there where your job is to relax by the beach.
I've thought about it.
All right, Lisa Marie Garza.
That's my case, Judge. She said on Thursday. I just want to see if you will recall it on Monday for me.
Okay,
I think we're supposed to get an offer that day.
all right. So that will be the 22nd,
Yes, ma'am.
and is your client on bond?
She is.
All right, will you be able to contact her and let her know?
Yes, I'll let her know. I just want to make sure it's okay. I just told her to show up on Monday.
All right, and so since you're already here, do you know if you've received the medical records? and-
Yes.
Oh, you've received all that? All right, we'll see you back then.
All right, thank you.
You're welcome. Oh, Norma, we have 4 people who they don't know if they're supposed to be in court or not.
Okay. No.
Yeah. Just. Yeah.
Bless you.
Yeah. Yeah. I think it's 615. Yeah. We were slated for this one. Yeah. I guess that's operation, right? What's the last time? Yeah. Didn't like it. Right? Yeah. Yeah. Do you have in your pocket? Huh? Have you ever heard of Trojan? Have you ever used that? It's in my good. Everybody's gonna get it. That's the plan. I mean, I tell you, you're gonna know. Huh? You're not gonna get it. He just infiltrated everything. Are you opposed to this? Oh, yeah, I've already heard it. Okay. Looking forward to hear. I mean. Get the song. I just think. Let me give you.
Yeah.
Sally's. Oh, yeah. I'm not gonna really get it very far. Once it comes around, it's just like, I think, yeah. Just give the chance.
Yes, Mayor Pro Tem.
Yes.
I have conferred as much as I can for and the state is.
All right,
So the
so,
court, it's a misdemeanor.
all right, so can you have the clerks pull the file for me?
Oh, of course.
Yes.
Thank you.
And then we will hear it. Have you filed a motion?
Yeah, I think so.
All right, if you can pull the motion and find out if the state is, if you haven't filed a motion, find out if the state will object to an oral motion.
Okay. That would.
Anyway.
Which case? We don't have it. Why did you do that?
Judge, the state doesn't object. I didn't follow it. They said they don't object.
Okay.
And here's the.
All right, thank you. Mr. Mauer, is your client in custody?
He was in my office earlier.
All right.
Just gonna have you give me an amount. I was just taking down to the satellite office.
Okay, so since we're going on the record, I'll need him here. And then they'll take him to the satellite.
Okay, I'll probably have to try to do it tomorrow.
All right, so if you tomorrow, just have him here first thing in the morning and we'll take it up first thing. And usually we don't have docket on Wednesday because we're in jury trial. So just make sure he's here at 9 a.m.
Okay, and I'll just leave the, all these.
Okay, all righty. And then Norma, the defense is going to bring Antonio Casablanca in here tomorrow at 9 a.m. for us to have a hearing on his bond request.
No, it's an invite.
Or if you want.
Oh, we could do that too. That way I can just walk him straight down the hall.
I mean, if you want to.
Yeah, can we do it now? Because that way I can just walk him straight down my house.
One of those dogs.
Good morning.
Oh, yeah, it's my yes, so you know. It was kind of a. $60 and how much
The body.
I'll let you know as we get it.
Around.
Looks like there's no process in it as a purchase.
Sure. we have another question from the jury. So I'm proposing that we're not on the record yet. I'm proposing the answer to that is that you have all the law because we can't send back police reports. So I'm going to print out what I propose to send. And once the interpreter is here, we'll put it on the record. But I'm going to see if you all have any objections to what the court is sending. And they haven't stated what the dispute is, so I can't answer that. Norma, could you? Thank you. State defense, this is what I'm proposing. Is there going to be objections to that?
Yes, no.
All right, so once the interpreter comes down, we'll put it on the record. All right, and I do have all the paperwork for Mr. Witron. So, counsel, if you just give us a moment, the interpreter is coming down, and I want to take this matter up, and then I'll take Mr. Witron up. Thank you. Caroline, are they pleading on one case? Okay. All right, thank you. Oh, the interpreter is here. Hello. All right, could I have the parties approach on Mr. Sanchez? Deputy Laura, is it hot in here or is it? Who complained? I bet you it was someone who doesn't live here. Like you say, you don't live here, you can't complain about the temperature. All right, so we're going to go on the record. In 2019 CR 6322, the court is in receipt of a question from the jurors. We have an interpreter here. The interpreter has been previously sworn and you're still under oath. The question is, the jury is in dispute about Officer Feliciano's reference to the police report. We would like to see the copy he read on the witness stand. And they say the copy of the police report. Have both parties had a chance to review the question, state?
Yes, Your Honor.
Defense.
Yes, Your Honor.
The court proposes the following answer. With reference to your inquiry, you now have before you all the testimony, exhibits, and evidence that was admitted, and you have all the law before you. Please continue your deliberations. Any objections to that answer, state?
No.
Defense.
No, Your Honor.
All right. Thank you.
Thank you, Your Honor.
Thank you.
My pleasure. May I be excused? Your
Yes.
Honor?
Have a great day.
You too.
All right. Court is going to call 2017 CR 10603, State of Texas versus Gregory Witron. Can I have parties announced for the record for the state?
Casey Garahan, Your Honor.
Defense?
Put written out for the defense.
All right. And are you Mr. Witron?
Yes, Your Honor.
All right. Counsel, have you received all the discovery in this case and did you review it with your client?
Have Your Honor.
Court will find that the state is in compliance with discovery. And Ms. Abrams, there's no application on this case. Mr. Witron, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're waiving individual paragraphs.
Any objection?
We're also waiving count two. And we're waiving count two, Your Honor.
Any objections? All right, then it's the court understanding that you're proceeding on count one. Is that correct? State and defense?
It is, Your Honor. It is, Your Honor.
Mr. Witron, I'm showing you what's entitled Court's Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of aggravated assault with a deadly weapon? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into pleas into this plea?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
All right, off the record. Mr. Garaham, I gave you the wrong copy. Thank you.
Here's the right one.
I didn't think.
Yeah. Counsel, do you believe your client is currently competent, was legally sane at the time of the offense?
I do, Your Honor.
Mr. Witron, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
Oh, yeah.
Has anyone promised you anything other than the plea? Satisfied with the way you've been represented? As citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on count 1. Punishment is to be assessed at 12 years in the prison. There's an affirmative finding of deadly weapon. There is no applications and several cases will be taken in consideration. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
There are none.
Then to count 1, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Your Honor. State exhibit number 1 with all its attachments.
Any
Reviewed the
objection?
Document and have no objection, Your Honor.
All right, state you may continue to confer.
Thank you.
Mr. Witron, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence its exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor, just follow plea bargain.
All right, the court is going to sentence you to 12 years in prison, give you credit for any time served. There's an affirmative finding of deadly weapon. Court will take in consideration the following cause numbers: 2017 CR 7677, 4641, 8564, 2018 CR 1479, 2017 CR 10602, and 7678. Is there anything else with regards to sentencing?
Nothing further, Your Honor.
Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, sir.
All right, we can go off the record. Mr. Witron, from reading the police report, it appears that there may be more going on than that's in the police report. How old are you?
41.
You're going to have to make a decision on what you want to do with the rest of your life. If you want to be in the prison the rest of your life, I guarantee you Texas has a prison available for you. If you don't change your ways, you're going to find yourself in and out of somebody's jail and in and out of somebody's prison. You're going to wake up and find that a majority of your life has been spent in confinement. So during these 12 years or however long you serve, you need to start looking internally on where you want your life to be. You understand?
Sure.
All right. Good luck to you.
Thank you.
You're welcome.
Be excused.
Yes. Mr. Gerhan. On this one, it's not check the reason why. It's not check the reason why. Thank you. All right, could I see the parties on Manuel Gaytan?
Your Honor, this is Mr. Wood's case. He stepped out. He said he'll be right back.
All right, thank you. And Bashan on Gaytan or Gatan, there's no application. All right, Gilbert Gonzalez. Who's the attorney on Gilbert Gonzalez? All right, and Bashan, this is an application for deferred.
Oh.
Are you all only pleading to one case?
Correct, Judge. She needs to speak up so she can hear you, okay?
And Norma, can you see if Mr. Wood can get here? Because I want to make sure we recess at noon today. Court is calling 2022 CR 11923A, State of Texas versus Gilbert Gonzalez. Can I have parties announced for the record for the state
Lindsay Shaw for the state.
defense?
Kelly Piddle?
Are you Mr. Gonzalez?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Gonzalez, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes.
Showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
No, Your Honor, the state's proceeding on the lesser included offense of kidnapping
No, Judge.
And from which count?
from count one. I'm sorry.
And so you're waiving count two?
Yes, ma'am.
Any objection?
No.
Mr. Gonzalez, I'm showing you what is entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand the state is proceeding on the lesser included offense of kidnapping as a third-degree felony? The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Gonzalez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything? That's okay. Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. I'm going to show you what's entitled the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count one and the lesser included of that, a kidnapping. They're asking that your fine be assessed at $500. The state recommends deferred adjudication. They're taking in consideration 2022 CR 11863 and 694518. And you're agreeing that you acted as a party with the co-defendants. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes.
State?
Yes, Your Honor.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No.
Outside the plea bargain agreement, the state is asking that your deferred adjudication be for a term of 8 years. There'll be a TAP evaluation, community service hours, and no contact with the complainant. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the lesser included offense of kidnapping in count one, how do you plead? Guilty, not guilty, or no contest? State any evidence?
The state offer states Exhibit 1 and all attachments.
Any objection?
No objection.
All right, state, you may be excused to confer. showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, just one moment. Did y'all intend to include the court admonishments again in the
I
stip?
think it was a duplicate, Judge.
All right.
I saw that, but I didn't want to remove it. It's no big deal to us unless you want it removed.
No, I'll keep it in here.
Was it 2?
Yes.
Okay, I knew I had printed one for probation, but I didn't know where it was.
Well, let me ask you, is there any objection? Because I know this has been file stamped, but is there any objection? Because I think it's going to be confusing to somebody who maybe comes along later and read this.
Sure.
Is there any objection to removing the court admonishments that's again printed?
Not from us.
I'm sorry, Judge.
Oh, no problem. Caroline. You know, remove a staple remover.
It's in that.
Thank you. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Please, Judge.
All right. Is there anything you wish to say on behalf of your client?
We ask that you follow the plea bargain. He's very young. He understands that if he screws up, that you won't hesitate to send him to prison for up to 10 years. He got involved with the wrong people. I told him that his friends for the next 8 years are his mom and his grandpa. So we ask that you follow the plea bargain. He gets that he's here based upon his own actions.
Okay. How old are you?
18.
How far did you go in school?
I was still in school.
You're still in school? What do you do in your spare time?
Nothing. Work here and there.
All right, you have to do something. Are you laying around watching television? What are you doing all day?
I've been working outside on cards and stuff.
Okay. All right. And I'm assuming the feds are not picking this up?
No, Your Honor, not that I'm aware of.
No, ma'am, they're not.
All right. So I'm going to follow your agreement, sentence you to 8 years deferred adjudication. There's a $500 fine that will be probated. Take in consideration 2022 CR 11863 694-518. There is to be no contact with the defendants in this case, Pedro Alonso and Roberto Mendoza Perez. You agree that you acted as a party with Pedro Alonso and Roberto Mendoza Perez in this offense?
Yes, ma'am.
There's to be no contact with Benito Palomo. There's going to be 200 hours of community service restitution. I'm not waiving that. He's to obtain his degree or diploma. And then are you planning on going to college? What are you planning on doing with the rest of your life?
I'm going to college.
All right. So he's to obtain his high school diploma. And once he completes that, he is either going to go to a trade school or either you're going to college. And if you go to college, that's going to be full time. And for the court, that's at least 9 hours. Right. And if he goes to college and maintains full-time status, the 200 hours will be waived. All right, if you're given a UA today, what's the results going to be?
If you have to pee in a cup, would you be negative or positive for controlled substance?
Negative.
It's been in custody for 7 months, Judge, so not to say that that's possible.
All right, I'm sorry.
He's been in custody for 7 months, so it's not to say that's impossible.
Impossible, but yeah. Okay, so I'm going to want regular UAs and field visits 1 time per month. He should be working on school, so I'm not going to ask for employment at this time. And who are you living with?
My dad.
All right. He's to provide proof of residency. And once that residence is established, he is not to change residence without the court's permission. You understand?
Yes, ma'am.
Probation, is there anything he needs?
No, Your Honor.
All right. Is there anything else you need from the court to be successful?
No.
All right. I'm going to show you your trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? And did you sign it? All right. Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right. We can go off the record. I'm going to give you a few life lessons because sometimes we don't get our life lessons when we're supposed to get them. So your attorney informed me that you were running around. Please whisper. Your attorney told me that you were running around with the wrong crowd. Here's the thing about running around with the wrong crowd. If those 2 people were to come before me, you know what they would say? We're running around with the wrong crowd. And you know who that wrong crowd would be? That would be you. So you're going to have to do better. And the other thing that you need to realize, some people who are trying to come to the United States, they're coming here for a better life. And they're trying to support their family. What you did was cruel because you took people who were trying to come here. And then according to this, it's called kidnapping because you didn't release them. So you have somebody who's trying to cross over here to make a better life for them and their family. And you hold them and say, I'm not letting you go till you give me $800. You know what that is? That's building your happiness off someone else's misery. And that is not right. And I know your grandmother, your father, or whoever is in your life didn't teach you to be that way. And if they did, it's wrong. So here's my question for you. Who is the person in your life that you love more than anyone? Your mom. Now, how would you feel if your mom were trying to cross the border to get here? She gets here and maybe she's bringing her children with her. And somebody says, you know what, we're going to give you a ride and we're going to help you. And then they tell her, you need to come up with $800. And if you don't come up with the $800, we're not releasing you. And as a matter of fact, you're in a foreign land, you're a stranger. And what we're going to do is move you from place to place until you pay us. How would you feel about that? That's what you did. So you were building your happiness, a lousy $800. That's what you're saying somebody's life was worth. You were building your happiness off their misery. And you need to think about that. You understand? All right, good luck to you.
Thank you, Judge.
All right, so can I see the defense on the jury trial? All right, if you'll call the interpreter and call the attorneys. And you can share that with. Move on to another case. Thank you. All right, Mr. Wood.
Good morning, Judge.
Good morning. Are you ready on your case?
Yes, I am, Judge.
All right, and probation, there's no application.
Thank you.
Court is calling 2023 CR 3683, State of Texas versus Manuel Gaytan. Could I have parties announced for the record for the state?
Ruben Rivera for the state.
Defense?
Good morning, Judge. Ready for Mr. Gaytan?
And are you Mr. Gaytan?
Yes, ma'am.
Am I pronouncing your last name correctly?
Gaytan, yes, ma'am. That's correct.
All right, thank you. The Y is confusing me on my pronunciation. Counsel, have you received all the discovery in this case and did you review it with your client?
Yes, I have, Judge, and yes, I did.
Court will find that the state is in compliance with discovery. Mr. Gaytan, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
I do, Judge.
State, are you proceeding on the indictment as presented?
Proceeding on the lesser included offense of assault, bodily injury, married cohabitation.
Any objection?
No, Judge.
Mr. Gaytan, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand the state is proceeding on the lesser included offense of assault, bodily injury, married or cohabitation as a Class A misdemeanor? Range of punishment is up to a $4,000 fine and up to 1 year in the Bexar County Jail. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Judge, and I explained to him that his waiver of constitutional rights was for this proceeding only.
All right. Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Gaytan, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor, tremendously.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand that?
Yes, Your Honor.
According to the plea bargain agreement, state is proceeding on the lesser included offense of assault, bodily injury, married cohabitation. They're asking that your punishment be assessed at 114 days in the Bexar County Jail. There are no applications and there's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent? Did you understand?
Yes, Your Honor.
Did you understand that to be the entirety of the plea bargain agreement?
Yes, ma'am.
Defense,
Yes, Judge.
state,
Yes, Your Honor.
showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Judge.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence to support the defendant's plea?
The state offers states exhibit 1 and all attachments, Your Honor.
No objections, Judge.
All right, state, you may be excused to continue to confer. Showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, so can anybody tell me, is he going to have charges with regards to the BMW that's in here? That he hit the BMW when he was leaving the location? Is there a pending charge?
Given time, sir.
Oh, that was the one from before. Judge, he got a time served offer previously. I think it was in January or February.
Okay.
In other words, there are no pending charges holding him.
All right, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find the defendant guilty, and the court will find the defendant guilty. Are we proceeding with sentencing?
Yes, Judge.
All right, anything you wish to say on behalf of your client?
No, Judge, he's just excited to get out and get back to work.
All right, state, did you speak to the complainant on this case?
We did, Your Honor. She's been a cooperative in the prosecution.
All right, the
She's
court.
aware of the offer that we presented.
All right, thank you. The court will find you guilty, sentence you to 114 days in the Bexar County Jail. There's an affirmative finding of family violence. Give you credit for any time served. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. How old are you?
I'm 40, just turned 40.
You need to learn how to be patient with people. You don't have the police come into your home because you have issues.
Yes, ma'am.
You understand?
Yes, ma'am.
So where did this get you? It got you a trip to the Bexar County Jail, a broken television set, and a remote doesn't work for the TV.
Yes, ma'am.
All right, good luck to you.
Thank you.
You're welcome.
Thank you, Judge. May I be excused, Judge?
Yes.
Thank you, Judge.
Can I see the parties on Juan Garcia-Sanchez? Norma, did you get in touch with the defense? All right, have Mr. Kimbrough come in because he's second chair.
Good morning, Your Honor.
Good morning. How are you doing?
Fine, thank you, Judge. Thank you for asking.
Oh, it's Mr. Kimbrough in the back?
No, he was here. He just walked in and he stepped out.
All right, everyone, just stand there. You know, they say that you need to stand up instead of sitting so much so everybody can get their exercise. Just give us a moment. This happens his mother to give you the address, and that's where he's to reside. All right. All right, Mr. Kimbrough, we have a question. Since you're second chair on this, if you can read that. And the proposed answer.
No objection.
Okay, all right, we're gonna go on the record. We're back on the record in 2019 CR 6322. We do have an interpreter. You're still under oath to translate. The jury has a question. The question is, the jury is in dispute about the medical doctor's expert witness process she gave in her testimony about how they evaluate the patient. Can we review that testimony? The proposed answer is, I have received your note. As you have been previously instructed under the law, I cannot read testimony back to you generally. You must have a specific dispute about the witness's testimony that you are asking about, and you will need to specify exactly what you are in dispute about. If the jury specifies as to what they are in disagreement about with regard to the statement of any witness, then they may, upon application to the court, have read to them from the court reporter's note just that part of such witness testimony or the particular point in dispute and no other. Any objections to that as the answer, defense?
Okay.
State?
Objection.
Any objection to sending this back to the jury? State?
No objection.
Defense?
No objection.
All right, thank you.
Thank you.
And Mr. Kimbrough, if you can have Mr. Leal come back here and tell him do not leave the courtroom.
I will.
All right, thank you. Yes.
We approach for your seat.
Yes. Okay. And then Norma, next I'll take up Mr. Simpson. Yes, thank you. Yes.
We approached this about a
Yes.
matter from yesterday, and I'm still working on your other matter. Can I come around here? Then you get one.
Yes.
Correct.
When you gonna retire, man?
Amy, what?
I hope you didn't get ink on the suit or anything from dropping the pen.
Oh, no, it's my glasses.
Oh, okay.
He's the new number one gonna be like. New number one.
Yes, he has a new number one, and then he now has the motion to revoke. That's been filed. Yes.
I just, I need to see about getting the file for the new number.
All right, is a new number one a criminal trial division? Norma, on this case, that's got to sit. Tell me what. Travis? On this new number one, he's going to need the state's file. He's going to be the pro tem.
You're in trial, but maybe I'll just get,
You have the SID number or
I have the case number,
case number? Oh, where's
the case number of the new number one.
Either one.
Night,
I can
that's
look
what,
it up.
it's Nightmag. 704
All right, can I
127.
see the attorneys on the case that we're in trial for?
I'll just send an email so that when I get back to the office after this docket or whatever we're doing today, I will be able to instruct T-Dot Banks, and what's the so it's Scott Simpson, I hope you're in the printers, CLTT, and sign PSON. Lawyer, my client. T-Dot Banks and Bear Island.
And Norma, I'm going to need the court reporter to hear.
So obviously, if you're gonna give up 10 on the deliberation,
No, I mean the one who did the jury trial. And you can give that to the defense. Who's here on Ella Zara Ibanez?
Your Honor, my client is.
All right, come down, please.
Thank you.
Okay, so why didn't he show up for court?
Your Honor, I'm not so sure, I'm not sure if it was an FTA or if it was a bondsman forfeiture.
Oh, on January 27th, he was a no-show.
Okay, that would be right.
All right, so with regards to setting this bond, this will need to go to Judge Nahara because we're supposed to send bond matters to him.
Even if we have an agreement, Your Honor?
Yes, but we'll be able to get it done today. If you have the motion, they'll be able to do it today.
We had just done a B page, we hadn't filed a motion.
If you file a motion today, he can get it done today. We can perhaps put him on the docket for the afternoon to have him sent to Judge Nahara. Is that, if that's okay with defense, or if you want to bring it back for tomorrow?
We can do it today in the afternoon. Lindsay, would that require you going down there?
If it's if the state's an agreement, I don't see why I need to be down there, but if we do, then one of us can certainly be down there.
Okay. And is this case on the docket today?
Yes, Your Honor.
All right. So where are we on discovery?
I believe we've signed a discovery acknowledgement.
I don't have one. So if you all have all the discovery, and if you do a discovery acknowledgement.
Yes.
All right. And then was an offer tendered?
Yes, Your Honor, and it is being respectfully declined.
All right. Well, was it tendered today?
Yes, Your Honor.
All right. So what I'm going to do is I'm going to recall this for a plea deadline date. Ms. Ferguson, can you put this towards the end of this month, maybe the week of the 29th?
That's fine, Your Honor.
All right. So we'll be back on June 1st. June 1st will be your plea deadline date. At that time, you'll need to let the court know whether you're accepting or rejecting the state's offer. Do you understand? And Ms. Ferguson, can you give him a reset form, please? All right. And yes.
We'll be in here anyway.
I signed my portion of it, Judge.
Okay.
I got with the prosecutor. We'll get you back, we finish this trial, I'll give you the file, I'm not signing for it. Everybody sign the thing except for the file.
Okay. All right. Thank you. All right. And I'll fill this out.
Is it possible to get the very last page pulled off, because that's got John Perez's email address?
Yes. All right, and what I'll do is, Ms. Ferguson, they'll make a copy for you.
Sure. Yeah, no worries.
It's good seeing you. How are you doing?
Yeah, I haven't been in this court since you moved. I don't know. There's nothing in the one we
Yeah.
I have more federal stuff in the United States.
Oh, well, we need to see see you more often. I was like, where's Scott? Is
I
he?
work less, Judge.
Okay.
I'm in my 60s.
Oh, gosh.
When you were saying about being 40, learning patience, like I'm 62, I haven't got any more patience.
Oh. Well, I'm in the twilight of my life, so it's.
You are not, you're like, oh, Jesus Christ.
Yeah, I'm telling you, it's like, yeah, I'm in the twilight.
I'm 62 and none of the Simpson men have lived past 70. So that's the twilight.
Oh, you're gonna make it past then.
Mark Simpson.
Yeah. Hey, there you go.
Well, yeah.
All right, did you need me for anything else?
Your Honor, I think the next one is also mine.
Who is your next one?
It should be Jose Lozano.
Yes,
Yes, thank you.
you anticipate. All right, Jose Lozano, if you come forward.
On that one, Your Honor, the state has a motion for continuance, which Daniel filed.
All right, and do you have any objections to that?
We have pro forma, respectfully object, but defer to the court.
All right, so what is is this a motion to revoke? Let me see.
The trial case is the new number. The MTR was resolved a long time ago. It's just the trial case that's in front of the court.
Okay. So today is a jury trial. So if you all can come back at 1:30, the court will hear motions.
Okay,
All right.
understood.
All
Thank
right,
you, Your
thank
Honor.
you. You're welcome.
We'll be back.
Is this coming back at 1:30? Norma, have you been in touch with that court reporter?
She's busy and Judge messes with me right now, Judge.
I don't understand why, if you're a court reporter for a jury trial, that you would not say you cannot be in another court because the juries have questions. I'm going to take these matters up, and then defense and state, we're going to walk over to the other court so we can get the answer to that question. And state, you did tender, all right, do not lose that question. All right, this is an application for deferred adjudication. This is James Brooks. Court is calling 2022 CR 8814, State of Texas versus James Williams Brooks. Can I have parties announced for the record for the state?
Rene
Defense.
Munoz on behalf of Mr. James Brooks.
And are you Mr. Brooks? Counsel, you received, and you're on the side. Counsel, have you received all the discovery in this case, and did you review it with your client?
That's correct, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Brooks, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it?
Yes, I understand.
And did you sign it?
Yes.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do so waive, Your Honor.
State, are you proceeding on the indictment as presented?
No, ma'am, the state is proceeding on the lesser included offense of cruelty to non-livestock, a class A misdemeanor.
Any objection?
No objection, Your Honor.
All right, Mr. Brooks, I'm going to show you what's entitled court's admonishments and defendant's affidavit and waivers. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, I reviewed it and signed it. I understand it.
All right, do you understand the state is proceeding on the lesser included offense of cruelty to non-livestock as a class A misdemeanor? The range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yeah.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand that the court were to grant your application for deferred adjudication, If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine.
Yes.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
That's correct, Your Honor.
Mr. Brooks, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes.
According to the plea, state is proceeding on the lesser included offense and they're recommending deferred adjudication. Did you understand that to be the plea? Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
Showing you the paragraph entitled waiver repeal paragraph. Did you review that paragraph with your attorney? Did you understand it and did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your community supervision be for a term of 1 year. There'll be a TAP evaluation, 50 hours of community service restitution, pause or animal cruelty class, prohibited possession of firearm ownership, MIC caseload, and no animal ownership. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
At this time, the state offers State's Exhibit 1 and all attachments.
No objection, Your Honor.
States, you may continue to confer. Mr. Brooks, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding you guilty as you applied for deferred adjudication. Are we proceeding with sentencing?
If we may, Your Honor.
All right, what would you like to say in regards to your client?
Yes, Your Honor. I know you're reviewing portions of the offense report, and I know that some parts of it do seem egregious. My client had previously been in a back place struggling with his mental health. You can see that he was actually put forth on a mental health warrants around that time of these accusations, Judge. He has since completed successfully AOT with CHCS, had a dedicated case manager there, D'Antonique Walton, who just gave him positive remarks all the way through and has been consistent with his treatment for CHCS, getting the medication he's needed and stabilized. So that is why I believe it's part of the plea agreement that he be on the mentally ill offender caseload, Judge, so he can continue to make progress in terms of his treatment. He's doing well. He's in a much better place now. He has been under pretrial supervision ever since the charge and pendency of these cases since December of 2021, Judge, and has done very well with his pretrial officers. So it seems he's getting the help he's needed, and we are encouraging him to continue that, Judge. And we respectfully ask that he follow the plea bargain agreement, allow him to be supervised by the court. This is his only offense he's ever been charged with. And he does not have any criminal history aside from this charge, Judge.
All right. And who is he living with? Or is he living by himself?
My parents.
All right. Are you employed?
Currently not employed.
All right, off the record for a moment. Defense state, here's another question for you.
Oh,
I mean, please review that. All right, I'm sorry. No, come back up. I was just handing them a question from the
Okay.
jurors.
Yes, Your Honor, of course.
All right. So we were talking about your employment. What do you do? Or are you not employed?
I'm currently unemployed.
All right. So how do you spend your time?
I read a lot. I'm currently looking for a job. I haven't really been able to keep a job, but I've been doing like manual labor the majority of the time. I haven't been working the past month. I've been working through staffing services and stuff like that.
All right. What's your diagnosis?
It's they said it was schizophrenia.
Okay. All right. Here's the thing. There's no shame in saying that. It's an illness like any other illness that people would have. Like if I have high blood pressure, which I do not, because otherwise my mom would be, my baby has high blood pressure. But if I were, guess what? It's an illness like any other, and you have to treat it. What I've noticed in my experience with clients who suffer from mental illness, they start doing great. They stop taking their medication, or they stop going through with their treatment. You cannot do that. And let me tell you why you cannot do that. It's because you're on probation here and you're looking up to a year. You understand? So it's going to be very important for you that you remain in contact with probation and keep communications with them open. You're going to have to make sure that you keep communication with your case manager, because what I'm going to require is probation is going to get a release from you so they can talk to your case manager. Do you understand?
Yes.
And how old are you?
25.
All right. Are you on SSI or anything of that nature?
I'm not familiar with SSI.
Okay. So that means that you're going to have to get in, he's going to have to get employment,
Okay.
or either he's going to have to, if he's going through SSI, then he can look into that. How far did you go in school?
I graduated high school successfully.
All right. So what are your hopes and dreams with your, what is your dream job? What are you planning on doing?
I wanted to go to college someday, get a degree, do something in the business world.
Okay, so why are you not doing that now? You know, if you have hopes and dreams, then you got to work towards those. You got to say, all right, I want to go to college. So you got to take steps towards that. If there is an application you need to fill out, then you need to fill out an application, turn it in. You understand? Just saying it, it's not going to make it happen. I think it was the lady from Scandal. I can't think of the lead actress's name, but you know what she said? She said, if you're trying to catch the train, you can't just watch the train pass by and not even try to run after it. Although I'm not recommending anyone run after a train. He was just using it as an analogy.
Yeah.
So if you have a dream that's out there, you got to go towards that dream. If you're not trying to go towards it, then you're just talking. You understand?
Yes.
All right, I'm going to sentence you to 1 year deferred adjudication. There is to be 50 hours of community service restitution. That will be considered satisfied once he takes the animal cruelty class.
Yes, sir.
There's to be, I guess, animal ownership. And when I say no animal ownership, Mr. Brooks, when I say no animal ownership, I mean all creatures great and small. So that means no goldfish, nothing. You understand?
Okay.
So there's to be no animal ownership. We're going to do the MIC caseload. I'm going to want, you can do the TAP evaluation out of custody. He's going to do a medical release. I'm going to want field visits 1 time per month until further notice. And probation, if you want to count those field visits, that's his reporting, you can. But I just want to make sure that his case manager is seeing him on a regular basis before field visits are discontinued. So you all need to confer with his case manager. Proof of employment within 45 days. There's to be no employment as a home health care provider with minors or anything involving animals. So that means there's to be no working at the zoo or anything like that.
Humane Society or anything like that.
Nothing like that. Probation. Is there anything else he needs?
No, Your Honor.
Is there anything else you need from the court to be successful?
No.
Show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes.
Because this is plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, good luck to you.
Thank you, Judge. We appreciate the court's time. May be excused.
Yes, and he'll just need to remain to go over conditions.
Yes, Your Honor. Will do. Thank you.
All right, can we go ahead and order food for the jurors, please? And you'll see what's available. Yes, please. Sure. Thought you were going to tell me something like major. All right, Courtney Pride. And everyone, the court is recessing at noon. So anyone who's on the jury docket and we have not addressed things, you're going to have to be here at 1. And the attorneys on that other case, please do not leave the courtroom. I'll talk to you all in just a minute. All right, what is happening today is her jury trial date.
Judge, her attorney is Luis Martinez. He is in trial in Kendall County.
You're telling me he can't be in 2 places at the same time?
It's tough. Sometimes I can do it, but
I know, I've seen you do it.
I know they are, they picked yesterday, they started testimony, and then they're going to break and not have trial Thursday, Friday, and then they're starting that following week.
All right,
Yeah.
so they'll be in trial the week of the 22nd, correct?
Yeah, Judge.
All right, Ms. Ferguson, can you place this case sometime after the week of the 29th for a jury trial? And it's a criminal trial division.
Yes, sir.
May 30th?
As far as I know, it's good for him.
All right, we'll see you back on May 30th. Ms. Ferguson will give you a reset form and then your excuse.
Judge.
You're welcome. All right, who's here on Pete Garcia? Pete Garcia. Oh, we've done with Alejandro. They keep giving you that file so you can get a workout because it's so thick. All right, Norma, we need. Mr. Porter is coming back at 1:30. We need Mr. Orta on Silly. All right, tell him he needs to. Deputy Laura, we are cutting off at noon. So anyone who is not here, they'll have to come back at 1:30 for their jury trial. So that goes for Sergio Salinas. That's 1:30. Raymond Ruiz, 1:30. Then we have Ed Cano. Where is he? That'll be 1:30. Ms. Ferguson for Ed Cano. Raymond Bell on Felix Apolinar. I thought that was taken care of yesterday, was it not?
That's a reset, Judge.
All right, thank you. And then Bill Davidson, is he here on Mr. Ruiz? Yes. All right, thank you. Sure. And Sergio Salinas is going to be 1:30.
That's gonna be a plea, Judge.
All right, thank you. And then we need Elizabeth Russell and Alfonso Cabanas. Yes.
Good morning, Your Honor.
Good morning.
I have been in other felony courts this morning doing various work, so I apologize for not being here.
You're here now.
I may be able to work out something. The thing is, on 1:30, I have a doctor's at 3 o'clock.
Okay, well, just continue to speak with your client.
Thank you.
All right, thank you.
Thank you.
It's always good seeing you.
Thanks, Your Honor. You too.
Okay, it's on the docket. All right. All right, so that's coming back on Monday. All right. While you all are going over paperwork, defense state, we're going to travel down to the 226 to see about the answer to these questions. All right, everyone, please be seated. Okay, I'm still waiting for that email to come through. Pete Garcia.
Your Honor, Daniel DELIBERATIONS, here for him, you've read about the hauling. I've let him know that you're ready for him.
All right, thank you.
Your Honor, may I approach?
Yes,
This is on. the docket.
okay. Thank you. This is on the docket. All right, Pete Garcia.
I'm ready. I'm ready.
All right, thank you. Where's Mr. Garcia?
He is actually in custody, Your Honor, because he picked up a new case, and if it would please the court, I was gonna ask you to set a bond and nag him on it.
No, that'll be the job for Judge Nahara.
Okay.
But today we're here on this case for plea deadline days. So what's happening?
Respectfully rejected, Your Honor. We're ready to trial.
All right, Mr. Garcia, your plea deadline date has expired. Miss, how long are you expecting this jury trial?
3-4 days. Your Honor.
All right, Ms. Ferguson, what day can we call this back for jury trial? All right, your jury trial date is going to be June 20th. And can you give them a reset form? And then he has an issue on a bond matter, if you can send that to Judge Nahara. Okay,
Well, he's never been, this is the first arrest. He's never been a bond sitting.
okay,
Still need a motion.
all right, no. Can you send it to Judge Nahara? He's never been magistrated. All right. All right, so they'll do it.
Well, Judge, in that case, Your Honor, sorry.
I'm going to email Judge Nahara and ask him to do it today.
Okay, otherwise he can just go back to the jail and get done quicker. But yes, with Judge Nahara.
Oh, well, do you want him sent back to the jail to have them do it there? All right, we'll see what happens.
Yeah,
Just let Judge Nahara know, please.
thank you, Your Honor. Thank you very much.
All right. Let me send an email to Judge Nahara.
That's just a minute. I'm sorry, not even. But you're not, you're just not listening. Okay. Second, it's that second. I will, that's what I- Did you sign the paperwork? Maybe excuse?
Yes.
Thank you very much, John.
All right, and excuse me, counsel. Mr. De La Garza. Yes, please. Norma, they want to know if they should send their deputy to get him, and he said he'll take it.
It's up to you, bottom.
Do you want the deputy sent or not? Okay.
Mayor Pro Tem? Did you?
Yes. Judge Nahara said he's able to do it.
Okay, excellent.
So if you'll go down to Judge Nahara.
Thank you.
All right, I let him know. Mr. Porter, I have your motion. That was quick. The agreed order. Yeah.
I just attach those conditions.
All right, thank you. Thank you.
Yeah.
Yeah.
Okay, thank you.
Can you mute us, please?